Yeah, hello, everyone. On behalf of the ASAL Intellectual Property Interest Group, I would like to welcome you to the online panel, Going Green, Navigating Intellectual Property Law in Times of Global Challenges and Sustainability Transitions. My name is Felipe de Andrade, and I will be moderating this panel. So the objective of this panel is to discuss the evolving role of intellectual property law in fostering innovation, diffusion, and the transfer of green technologies. So against the backdrop of what we call the triple planetary crisis, so climate change, pollution, and loss of biodiversity, our panelists will reflect on research methods and perspectives to review how intellectual property impacts the transition to a more sustainable future. So our panelists for today are Professor A.B. Brown, Professor of Intellectual Property Law at the University of Aberdeen School of Law in Scotland, Professor Dali Diambo Shabalala, Professor of Law at the Suffolk University Law School and Academic Co-Director of the Suffolk Law Intellectual Property Center, and Professor Joyce Young, Professor of Law at Peking University School of Transnational Law. Audience questions will be invited in the last part of the panel. And for that, we have a Q&A function here at the bottom. So make use of that if you have any questions, and we will address them at the end. So without further ado, I'll give the floor to our first speaker, Dalian Shabalala, who will start the discussion by reflecting on research methods and perspectives on IP law and sustainability transitions. Thank you.
Thank you, Felipe, and for the chance to come back and revisit this topic at a time when I'm actually writing some on this work. I'm pleased to be on the panel with the other two professors. It's a great chance to have this discussion. So, as we were talking about a little bit before, we're in a situation where the issue of intellectual property, the overlap with climate change and technology transfer is becoming, I think, relevant again. And I think in part it's unavoidable because of our recent experience with the COVID-19 vaccines and the debate about access to them, right? As with the debate over access to HIV medications in the early 2000s, the issue was if and how patents were a barrier to accessing medicines. The core issue now, as then, was whether the patent holders of the vaccines were able to produce and distribute vaccines at sufficient volume and at a lower price to meet the global need. And if not, why they were not licensing as widely as possible to other manufacturers to do so. The data shows that Pfizer, Moderna neither licensed patents or made available trade secrets or know-how to other potential producers and only formed such partnerships when strongly encouraged by governments. And this pattern with respect to COVID is highly familiar. It represents one of the direst challenges to the modern intellectual property system. The generation of vaccines so quickly and so successfully is a miracle, right? And a vindication of the dynamic efficiency of the patent system. But yet the inability to provide for the rate and the level of distribution to the populations and countries where there was an obvious need and a significant demand is an indictment of the system's static efficiency, its ability to supply products to meet current demand. Now, this isn't a mistake, right? This is a policy decision by countries. In order to capture as much of the financial income and benefit for themselves, the vaccine-originated companies maintain ownership and control over the primary technology needed to make the vaccines. The clear lesson, I think, from the COVID experience, and that I think has raised this issue again, it shows that the explicit licensing behavior of originated companies is that such firms don't necessarily have inbuilt incentives to provide for licenses and for major production. The clarity that this experience with COVID provides suggests that it's time to revisit, I think, the sanguine consensus that's developed over the past 10 years that intellectual property is not a barrier to addressing climate change. That in a situation which presents just as much of a dire emergency and for which we're going to be dependent on the rate and the speed and the price of technology distribution, never before seen in human history, we should be thinking about what are the right policy levers and the right measures to take. So I argued before in my PhD and in other research that the right question to ask then isn't just the question of whether there is patenting, because I think the data and the results, a lot of research show that patents of patenting suggest that, yes, there's lots of patents in developed economies. There are patents in emerging economies, or what I think we should no longer call emerging economies, emerged economies like China, India, Brazil, maybe even South Africa, but very few patents in LDCs and even some of the middle income countries. But what we do not have is that the question isn't, just like with COVID, whether those developing countries have patents in them, it's whether they can purchase at the right price and at the right volume the products on the international market. And the best places to purchase those from are not from the companies in developed economies, because they're not selling into those markets, but from licensed high capacity producers in the emerging economies. China is the country that should be selling to Botswana and Ecuador and Nepal. India is the country, right, that should be selling to those. And so the real question is not so much where the patents are, but what the licenses allow for. If somebody licenses to India, does it allow them to then produce enough for export to other countries, or just for export back to the developed economy, like we saw with COVID? Or does it allow for export to other developing countries in that sense as well? So in that, I think the real question then is not so much what the patents are and where they are, but how are they being used? What are the terms of the licenses that allow us to produce at the right volume and at the right price for developing countries? And so I've really been interested in, when I was doing my research and what I did in the early years, was to ask that question: where and what do we know about that? The reason this matters, I think, is because it's easy to forget what the underlying structure of these technology markets are. And so I wanted to cover that a little bit before sort of reviewing some of the empirical data and information and suggesting where we might need to be thinking about this, right? So in a system with international trade, net exporter countries are going to try to see and get the most intellectual property protection and harmonized at the highest level possible. It's a purely rational decision on their part. Net importer countries are going to try to work around that. They will need less intellectual property protection and lower price and access to the goods. So again, this dynamic between developing and developing economies is built into the structure of the markets. If you leave everything just to the markets, you're going to end up with behavior that prevents domestic spillovers, international spillovers, and that's the design of the system. To try and capture as much of the value of spillovers, that's what the IP system of patents are for. But technology transfer requires that we maximize the ability and the amount of spillovers, not just to vertically integrated companies. So Nissan shouldn't, we're not talking technology transfer. Nissan transfers information and technology to a subsidiary in India or a subsidiary in China. We need them to also be making the technology available to their competitors in India, their competitors in China. And it is irrational to expect a market actor to do that voluntarily. Right? And so part of what I think we need to be thinking about is, as researchers, identifying what the actual licensing behavior is, and then asking what the actual regulatory interventions we can make that will address this market failure. And so it's not just that it's a market failure, it is the nature of the market. We shouldn't expect the market to act differently than it is. So if we understand that that's the nature of the market, it's the nature of the market structure, then we can see, oh, we have lots of behaviors here that we can point to that, right, license holders are going to engage in. Problems that we run into. There are information asymmetries between technology licenses and potential licensees. who don't have sufficient information to evaluate the utility of the technology. That is a problem in the market that we can maybe act to correct. There are information asymmetries between licensors and licensees as to the nature and the scope of the market into which the technology is being licensed, right? Making it difficult for licensors to assess the market potential and the market value at the appropriate price. Again, something we can address, but in particular, geographic restrictions that make it so that you're limited to your country or back to the developing country means that what we need to happen of getting that to other countries can be difficult. We have a tendency for technology holders to try to increase the natural exclusivity of the technology by masking the full nature and scope of the technology when they patent. Right? This can occur even where strong IP protection exists. The tendency to exercise market power to capture elements of product and technology markets upstream and downstream to the technology market in which the patent is held. And again, that is a normal market behavior that is built into the market structure. Right? And so all of those prevent spillovers, and the spillovers are what we want, right? It's not that we want to reduce spillovers, we want to increase those spillovers, and that is a counter market kind of intervention that we have to think about. We see tendencies for technology licensees to insist on exclusive licenses. Again, that's a problem. Exclusive licensing prevents the kinds of massive distribution and diffusion of technology that we want. Tendencies for licensors to insist on transferring only to wholly owned subsidiaries or majority-controlled joint ventures. Again, that creates a problem for us. And the kind of anti-competitive behaviors that we can see, refusals to license. Restrictive licensing terms on geographical scope, restrictive licensing terms on exports, engaging in tied sales, attempts to capture upstream and downstream markets, like I said, requiring licensees to further develop the technology to grant ownership or no-cost exclusive or non-exclusive grant-backed licenses, engaging in collusion, certain kinds of patent pools, predatory pricing, right? Behavior aimed at pushing out local market actors. So the argument here then is that any assessment of whether and how intellectual property forms a barrier to addressing climate change has to look not just at the prevalence of patenting, but also at the extent to which right holders engage in the kind of activities intended to prevent spillovers. And my argument is that much of the empirical research that we looked at, I looked at up until 2015, and I'm going to talk about between then and now, doesn't address that question. It addresses the question of the prevalence of patenting. I think that helped us with the first step. Where are the patents? Yes, in developed and developing economies. But it doesn't tell us much about licensing. And what data we do have is predicated on sort of the concerns of licensors who, right, say we are interested in getting as much IP protection as possible. That's great. But what we don't have good information on are the concerns of licensees and what terms those licensees are seeing that make it financially difficult for them to engage in reasonable licensing and negotiations going forward. So let me jump a little bit to sort of some of the conclusions we can draw from prior studies. So when we look at the work, a lot of the research still covers only a small proportion of technologies for mitigation and very few for adaptation. So in particular, energy efficiency, particular appliances, and transport are a significant gap where there has been a lot of study on even the patent prevalence, let alone licensing behavior. Providing IP suggests that it's likely to be a necessary, but not sufficient condition for achieving technology transfer, and it doesn't tell us what is the optimum level of IP protection necessary to allow for FDI, for joint ventures, and for licensing. There's a lot of variation across sectors and countries, and this means that there's not likely to be a one-size-fits-all set of policies, which places the onus on each country to develop its own policies, which means they all need sufficient room to operate and use a portfolio of policies rather than sort of a ceiling on what they can do. Market creation and market demand are crucial for ensuring that any of the market-based measures occur and that there's even a demand for the technology in the first place. Recent study from a group at Cambridge and others suggest that demand side measures are going to be key to addressing this issue. Export markets are crucial for licensees. So licensing to firms in India and China is useful and can help in production. But if those firms don't have access to export markets, there's not a really good, rational reason for them to engage in licensing. It only works if they have access to export markets for the products that they produce under those licenses. Again, this suggests that we need to really be looking at what are the licensing terms that people are suffering under. Fifth, demonstration diffusion rather than R&D will play the crucial part. Again, I think, as Abe, you've pointed out in other places, a lot of this technology is already out there. It's already available. Even a lot of it is not under patent. So the capacity to engage in demonstration and diffusion is more important. The vast majority of IP ownership in the limited sector studies, especially the FDI, is held by corporations who are primary producers of products that are manufactured on the technology, right? These are the companies least likely to license because they're engaging in production in the market themselves. So this tells us that even though we can maybe point to a place where there are other actors like academic and public institutions, ownership is relatively small, and national corporations and large-scale corporations are still going to be the people we have to deal with when thinking about our interventions. Finally, while licensing IP and exchanges in FDI do occur, that means IP is not an absolute barrier, but that's not the right question. The question is it happening? And are the exchanges happening at a fast enough rate and at a large enough scale? If we're thinking 2030, if we're thinking 2050 for diffusion of all existing technologies, and then hopefully, the latter part of the century for newer technologies, we're nowhere near the rate and the volume we need to get that diffusion. So again, I think if I was to exhort a research agenda, I would say that we need the data that shows what the licensing terms are that people are experiencing in those emerging economies. And then we need to see, are they able to export to those LDCs and other middle-income countries, and to think about how to create demand in those other countries for those technologies so that the export markets are there. So having hopefully set the stage for the discussion, I look forward to the discussion with the panelists. Thank you.
Thank you so much. Your presentation really touches upon topics that are going to be indeed addressed, for instance, by our last presenter, Joyce Young, when she talks about competition law and norms regulating anti-competitive behavior, the predatory pricing, and unwillingness to license. Maybe I could already ask you a couple of questions now so that you can explore a bit more what you said. You mentioned that the issue here is the problem that we face with intellectual property and climate change and licensing behavior is a sort of a problem in the design of the system. And that in order to address those design problems, we need to really be able to identify the problem or to identify the market failure and go forward for it. Do you have any examples of initiatives where these problems have been addressed already, or is this something that is really in these early stages and there is not a lot yet developed at the international or national level at that point?
So I think there are two historical periods that we can point to where we saw, right? And it's why there was a sort of a regulatory response. So we saw in some of the early sort of investment-related actions where, especially in China before it joined the WTO, we saw this sort of FDI-focused framework where countries that represented already very large markets, China being one of them, put in requirements for joint ventures. Joint ventures are amazing tools for technology transfer, right? You get training, you get information sharing, you get knowledge sharing. And then once the joint venture is over, that joint venture partner can then move on and engage in its own learning and then its own production. So that requirement of partnering with a local partner, requiring technology sharing in order to invest in the market, I think you saw a lot of that, and it was, I think, unmistakably highly effective in China. We saw this in Korea in the early stages of Korea, not just imitator, but also we saw a lot of joint ventures in South Korea during its growth phase. We see this somewhat with the chip manufacturing industry in Taiwan, right? You don't get the Chinese, the Taiwanese manufacturing industry with that kind of joint venture construct that allows learning and people to create their own businesses after they engage in those joint ventures. So that FDI focused component, I think we've seen a lot of learning from. The danger I think that we've seen is that while they haven't been able to put, you haven't seen the imposition of bilateral investment treaty limitations on China for that kind of joint venture work. You have seen it in lots of other countries. And China presents a unique sort of large market that people could not avoid wanting to go into. So China was able to leverage market attractiveness in that way. Other countries can't do that independently. Brazil, we did see some of that, a little bit in some aspects. We're beginning to see, we saw that with India in the automotive sector and the wind sector in the early part of the century. But again, we haven't seen that much, and we've seen a restriction of that policy space rather than an expansion of that policy space. I think one example, though, we have seen is that the sort of aggregation through regional trade agreements has been really useful in creating large conglomerated markets. So in Africa, we begin to see bigger markets being created by these trade agreements that then will enable larger sort of market attractiveness that way. We see this with Central America as well, with the Andean Pact. Don't get me started about Mercosur. It breaks my heart every time I think about it.
Okay. And another issue that you mentioned that I found quite interesting is that willingness to license, particularly willingness to license to your competitors. Because I believe there was a study from, I think, the European Patent Office on licensing by companies, and they interviewed many people, and they said some of those intellectual property owners said that they would be willing to license, for instance, to least developed countries under even mutually agreed terms, so beneficiary terms for those countries. What kind of measures do you think would actually encourage people, or as you to actually license to their competitors? Because when you think about these developed countries, there are not, it's hard to imagine that there will be a local competitor there for them. So that would explain why they would be more easily willing to license in that territory. Not the case for China, India, Brazil, and etc. Do you have any thoughts on that issue?
There's actually some, I think, some interesting evidences. So that EPO study in particular, I really enjoyed because I think it really highlighted a couple of things. One, willingness to license into LDCs is fine, but it's the lowest risk kind of licensing because they're never going to be competitors. There's not really absorptive capacity, and it's almost always vertical. We will be willing to actually set up a subsidiary there or some sort of joint venture there to do it, but building it from scratch. And I was happy to see that part of it, but I was also like, well, yes, that makes sense. What I want to see is if you would license to a company in Brazil, would the license allow them to export to Botswana, to Angola, to Malawi, etc., or would you want to really control that? And I get that, right? Which is, that's a harder thing. I do think the study also showed that the thing that they had the most concern about was not much the licensing, but if there was a dispute, what would happen? So I do think sort of it's less about the level of IP protection and more about the certainty related to contract negotiation and contract dispute settlement. And that this is where I would be happy to see much more arbitration. I've been really enthusiastic about WIPO Green and sort of the arbitration mechanism. It's linked to the WIPO arbitration mechanism. And I think that could be a way to think about it, a way to think about using legal certainty as a way to attract, because I think more than the level of protection, it's the legal certainty around being able to act to prevent contract disputes when they happen around licensing more than anything else that people are concerned about. I think the EPO study did show that as a big chunk of its work.
Thank you. So I will now, so for the other panelists, you can, if you have any questions for Professor Sharp, you can note them down and then mention that at the end of the panel. But for now, I will move to our next panelist, who is Professor Abby Brown, who will be discussing with us the regulatory interface between international and national policies on intellectual property and innovation. And then she will highlight some examples from key economic sectors undergoing sustainability transitions. And I'm very excited to hear her presentation. So Professor Abby Brown, you have the floor.
Fantastic. So thank you everyone for inviting me. Very honored to be here to this esteemed audience and my very esteemed co-panelists. So I'm going to have a focus on regulatory interface with an international and particularly a national focus, and hopefully complementing quite nicely the discussion we've already had. Briefly introduce, again, we've looked at it already, the power to exclude, the place of IP delivering sustainability, some of the present structures we have, but also, again, some different views on some of the realities we're actually having. How might we be able to change it? And then that builds on a lot of work I've done in the past already, so it's been great to have the chance to revisit it. But also recently I've been looking at some points engaging with raw materials and sustainability and the IP interface on that. And I think there's some threads which draw together there. So again, briefly, what's IP there for? IP can, as has been said, do a fabulous job. It can encourage the development of new things, and it does that really well. Even if we didn't decide we wanted to have that because of TRIPS, most countries are now obliged to have IP, and it's aiming to encourage innovation. It's aiming to deliver the public interest. There are some restrictions on when one might have IP in relation to sustainability and environmental protection. But broadly, if you're looking at commercializing, more commercializing, which is often what we're looking at here, the TRIPS exceptions aren't going to carve out. One can have exceptions, one can have licensing, one can get injunctions. Although, of course, you don't have to, and that flexibility can be problematic sometimes. Climate change, again, it's there, as we know. If one takes a narrow UNFCCC focus, it's about addressing human-generated CO2 emissions. We've spoken about mitigation, we've spoken about adaptation, and that very, very broadly, I'm not a scientist, but this is pretty much a human-generated problem. So perhaps what humans might be able to do to solve it. There's been quite a lot of engagement in the Framework Convention, the Kyoto Protocol, in the Paris Agreement. There's lots of discussions about technology. Our last speaker doesn't like Mercosur. I get very upset about the lack of relationship to an engagement with IP in these agreements. This might just be because I don't like being ignored, but I also think that if one is talking about technology and its transfer, you just can't go very far without engaging with IP. So we have structures, but we don't really have ways of drawing these threads together. And this is a real shame because only one example, of course, but IP can enable you technology to develop really important things to save. These are two of my favorite places. You will have your own. But of course, before one gets too combative, even on a Friday, the IP system, the IP treaties, the climate change treaties, they can be absolutely consistent. They can and often do work together, but we can make them work better. And I'm going to explore some possibilities building on our last speaker and how we might do that. And even though it's probably not all about IP, Navraj Singh Gali, quite a few years ago in a book we worked on together, and Robert Burrell and colleagues more recently have argued, well, maybe it's not all about IP. Well, maybe. But that doesn't mean it's not about IP. It doesn't mean we can't do more about it. There's been a lot of work exploring this, I think, at international level, from a treaty interpretation-based angle, from a regime interaction-based, a regime shifting-based angle. So that, if that's your scholarly interest or your practical interest, there's a lot of work there. I don't think IP and climate change are so distinct there. We're also seeing IP and climate change interacting across, frankly, most of the Sustainable Development Goals. I have mixed views on the Sustainable Development Goals. I'd love it if we had the chance to discuss it, but they've become much more entrenched over the years, I think, as indicators of corporate behaviour, amongst others. So we can, but as with human rights, perhaps, one can see Sustainable Development Goals which encourage IP and some which encourage climate change, and it's still not quite clear how these might really tie together. Conversely, perhaps through the Aarhus Convention and other human rights-based instruments in relation to environmental information, climate change, human rights, and a recent report by my friend and colleague Lisa Morguera, 2024, we're seeing a bit of increasing recognition of the relation between information, IP, and climate change there. Perhaps less engagement or at least stalling TRIPS Council work on climate change, but increasing activity, and we've got a US report there, but the WTO is starting to engage with climate change. This is perhaps a debate for another day, or we could touch on that here, but whether that is going to go perhaps in the most inclusive and effective and non-corporate manner, without, of course, while recognising that the corporate voice, the private property rights, the making the most benefit of intellectual property has such an important place. How do we manage that place as effectively as we possibly can? And the final twist in all of that, from the totally other side, is arguments based on the Earth Charter, Universal Declaration of Rights of Mother Earth, for example. Very, very disparate from trade, but actually as one set that out here, these do all, I think, intertwine. So we have that international framework, which is live and active. Perhaps, I think, less visible, certainly from my experience. Now, my examples are very much based on the UK. I'd love it if we have time to hear what's happening elsewhere in the world. But from work I have done in the past and conversations over the years, I don't think it's that different. So intellectual property, it's at UK level. So that means only London legislates for UK for IP, not at the Scottish level, which broadly is a bit more state-based. We have laws that give the private right to exclude. We have no specific reference to the climate change in our IP laws, which is a bit of a problem. We can have many exceptions, but they are optional. We have climate change laws in the UK and at Scotland, just to make life really, really complicated. This imposes obligations on the states and on public authorities to reduce emissions. It doesn't talk about what if that really great bit of technology is under the control of a private owner who doesn't want to license it, as we've seen in our previous situation. There's lots of reporting, but not about IP. And in Hansard, our parliamentary record, no reference to IP. So does this matter? Now, we've seen many arguments, maybe it doesn't, maybe I just want attention, but I think it certainly can matter. It's not the only thing that matters. But say someone develops a silent wind turbine, doesn't kill the birds, really important. We also have an environmental NGO annoyed that Scotland isn't doing enough to reduce its emissions. It would really like, local authorities might like to use more of these technologies. Patent owner won't share it. There's a total fight. No one can get on. This is why I think it's very, very important that these fields are made to come together. As has been seen, there's a few extra twists when we look at the climate change IP interface. Very much agree that there's a lot of analogies of what we've seen from COVID, but it is different. There are other ways of engaging with climate change. If you're my mother, you could wear a jumper or a sweater, however one might call it. One might say, surely people will share. Now, rationally, of course, often it is sensible to share. We've seen an increased role of ESG, bodies like B Corp, WIPO Green, Technology Needs Assessment. Chancery Lane project provides a fantastic example of pro-climate friendly corporate boilerplate clauses. The world, I think, is changing a little bit. But we're also seeing a lot of litigation, for example, at the ITC, trade secrets, climate change technologies, and a big patent fight. One example in the UK, Siemens against General Electric. So the world does involve IP and people don't always agree. And broadly, if your IP law doesn't talk about climate change, your IP fight in court won't talk about climate change. It's not relevant. It's someone else's problem. Well, I don't think it is someone else's problem, and that's kind of been my career, to try and make it drawn more together. There's a few things one can play with. I've developed some arguments trying to bring wild law type approaches when you're arguing how human rights, climate change, patent laws should be interpreted together so the courts can reach a new change. There's some new momentum, I think, coming from that. Very famous Mary Robinson was speaking to the Law Society of Scotland fairly recently. The courts need to change. Well, this is perhaps a way that they could change, as well as simply wanting to change. And from the UK, we have the Environment Act 2021, which requires people passing legislation to look at certain environmental principles and for the Minister and Parliament to say that they have regard to this. So the world is changing. Lots of other pieces of litigation, for example, Netherlands and Pakistan, having regard to precaution and climate change in court actions which are going there, quite a wide range of actions that we're seeing. And I think one can, going from that, particularly in an interlocutory situation, is someone going to grant an injunction saying no wind farm? Anything that one can use to say, no, don't. We can fight about the money later. But please don't grant an injunction, say, don't use the technology now. I think a lot of these arguments can be helpful there. But before we get too excited on a Friday, there's also lots of examples of litigation and legislation with a much more older school example, shall we say. There have been some examples of litigation in Scotland and in England which have had a more pro-climate outcome, but broadly in relation to oil and gas decision-making, for example, we're finding decisions which are, say, we're doing the law doesn't say favour climate change, go away later, very broadly. We have US Special 301 trade report stressing the importance of IP and particularly noting that in relation to sustainability, environmental and climate change. Again, I'm the first to say there's a huge space for IP in encouraging responses to climate change, but this seems perhaps to a welcome discussion to be a more a traditional non-sharing, non-enabling type of approach. We can see that in the US Patents for Humanity Act, which I think is pretty good. There was a similar thing in the EPO for a while, but broadly the answer is get more patents more quickly. Yes, that can help, but that will not be the whole answer. We do reference to investor-state settlement trade agreements. One of my favorite cases, I have lots of favorite cases, but there was a fascinating piece of litigation in Canada where there was legislation broadly requiring information about oil, where the oil is, to be shared very widely, even if it was subject to copyright. And the National Court said, yeah, you're right, that's what they meant to do. But this victory, if one seeks to prevail over copyright in that situation, has now been countered by a NAFTA challenge by the copyright owner, a real reminder that the battle continues to go on, which is, of course, because there's a lot to be said for IP. Changing direction slightly, I've now started to look at this from a very different angle, and it was very nice to the chance to realise that what I've done over the last couple of years actually is very, very intertwined with what I've been doing in IP and climate change all this time. Broadly, soil, I'd never thought about it before, but what soil is made up of is very, very important for responding to climate, as lots and lots of other things. Information about what is in the soil used to sit in wonderful data libraries, and it now sits online. Now, for us, if you're like me, your brain jumps quite quickly to the fact, well, there'll be database rights and copyright in that database. The scientists don't think that way, believe me, but they do think that. And what I found absolutely fascinating is digging into what approaches have been taken to, as I see it, control over this really essential information about the soil. Oops, it's not working. There we go. You don't know much about, if you don't know much about the UK, very briefly, Scotland, England, we're not always best friends, although we are friendly neighbours. So it'll be very interesting to see that in England, Margaret Thatcher's government in the 1980s very broadly privatised the English soil survey, whereas Scotland, we've taken a very, very open sharing approach and it's made available to everyone. So this is a fascinating example of, again, back to what we were saying earlier on, a straight policy choice about what is going to be done. One jumped one way, one jumped the other. Benefits can, of course, be argued for both, but it's really interesting to see that side-by-side decision. And here we have a quote in the British Parliament, but it said the money must be developed from commercial activities in England. Straight decision, 1985. In Scotland, They're seeing this soil is of national importance. It must be shared widely as possible without restriction for commercial or non-commercial purposes. So just two very different approaches. And what everyone thinks about this, I think it's very interesting. It can be done. People who say it can't be done, you know, it can. And if you want to know more about the soil map of Scotland, there it is. And these slides, I'm very happy for them to be shared more widely. The ocean is a place that's been taking me more recently. I had never known about this before, so I'm very grateful to chemistry colleagues who took me on this journey. But broadly, there's the UN Convention of the Law of the Sea, and it left largely unregulated the big bit in the middle, beyond national boundaries. And there's just been negotiations about this, looking at environmental protection, marine protected areas, but also the question of access and benefit sharing. Very broadly, the idea that colleagues, like my chemist friends, they get the plankton and they turn it into drugs, such as COVID drugs or bioenergy, lots of amazing things which can be done. Firstly, it was done with the plankton. Now it's actually more and more done by the plankton in digital form, and then the sons and daughters of that digital form, but still based in something which really was seen as arguably belonging to everyone. But then we're going on a path to a privately owned intellectual property right. And what I loved about being in this space, the privilege to go to some of the negotiations, was there was hardly any IP lawyers there. And everyone in the room kind of said, well, we'll share the benefits. And I was like, they wouldn't, you know? And it was to make people aware of the complex, difficult debates that we have very much in the IP world, what everyone thinks about them, to suggest to the climate change law of the sea world that one must think about IP rights was really quite a challenge. Now, some had always been aware of it, and lots of challenge actually about there being a patent in the first place, which is an interesting point given our first set of discussions, and a little bit about fear of money and where might money go. But in the end, hardly any references to IP in this agreement. So we have an agreement which is about technology transfer, about access and benefit sharing from a raw material which arguably belongs to all, and it doesn't talk much about IP. Quickly, don't panic, Felipe. In the public sector, public-private interface using the UK as some examples, we've seen a lot of change. We've just had a general election. We're seeing a bit of a movement towards mission-based agreement, more of a movement towards more state-based funding to do things that the state thinks is important. What everyone thinks about that, that's been a little bit of a change. Still, in my view, not enough engagement with how this is going to work in relation to IP. Point one, or point two, when there is engagement with IP, the standard, well, of course, we've got to have IP, we reward innovation. That's a legitimate view, but again, it's not a complete view. Mazzucato's work is becoming increasingly recognized. She's very much been a driver of the mission-based economy. So she's much more alert to, should there be more of a public-based approach to IP? So it will be interesting to see where that goes. And finally, as if we didn't need another international space, which is relevant here, the World Health Organization continuing to try to negotiate a pandemic agreement, building on lessons learned from COVID. It talks a lot, about sustainability, financing, local production, talks about technology transfer. They still can't work out if they're going to talk about IP. And while I understand that, given everything we have lived through in the IP and climate change space, I find that really quite concerning. So this is real, it's topical. We were saying before we come online, we think it's very important. It's become very high profile again, and I think that's absolutely invaluable. I think it's timely to question a lot of assumptions. I think it's important we don't just go around in the circles. We've gone again, not just go back to Copenhagen 2009, the first EPO report, for example. We're seeing more of a shift to a public mission and state-based approach, but I think there's a lot more discussion to be done. So thank you to ISIL for organising this, and I really look forward to our discussion. Thank you. And that's me, hopefully. I am back, yes.
Fantastic, yeah. So that was a great presentation. I really learned a lot from it. Maybe I would like to start actually by asking you about this different reality that in UK national law, there is no reference to IP on the national climate change debate. And then you said it's someone else's problem in the presentation, because when you discuss patents before court, you're discussing patent disputes. Nobody talks about climate change. Nobody talks about any of the other challenges that we face. So what would be then the role of, for instance, courts and also from government agencies, which are actually the authorities that are implementing both intellectual property and climate change policies, in connecting these discussions, actually, and what are the mechanisms that they can use for that? So maybe you can start by developing that, and then I can ask other things.
Of course, thank you. So I think one of the things, starting with government agencies, I think they have a lot more flexibility because they are part of a national system. We just signed up to TRIPS and are signed up to the International Climate Change Agreement. They have a wealth of literature and scholarship and policy work available to them, which shows that there is this overlap between them. The view that IP is not a wholly unquestioned good, and even if it is a wholly unquestioned good, simply saying, as nearly all our policy papers do, yes, IP will encourage innovation, then it will be adopted. There's a few more steps that need to be worked through in that, and for there to be some deeper engagement with that, some drawing on other work. I mean, R&D tax credits, patent box tax, for example, they're not perfect either, but to draw these things together to work out if there is IP, how can one ensure that these technologies are actually being adopted? Because basically, the first thing I do, I'm lazy, obviously, but the first thing I do when I get a climate change policy document is I cut and paste and I search for patent. It's never there. And it just makes me so incredibly annoyed. So in some of my previous work, I suggested ways for inviting different bodies to respond to consultations, ensuring that lots of different government departments are involved in drafting legislation and policy work together, secondments, things like that, to draw them together. It's not easy. Of course, it's not easy, but I'm not really convinced that anyone is actually trying at the policy thing. And that goes back to lots of points about segmentation, different goals, different expertise. If you're an expert in climate change, you've never heard about IP. Someone says, oh, go and speak to that department. They say, oh, IP encourages innovation. Don't fetter it. There'll never be any more. Then you're going to believe that. That's not an unreasonable view, but I would suggest there's a more complex view which could be developed. In relation to courts, in some ways it's much harder because you're working with the confines of legislation. So Patents Act, you're not to do this without consent. Climate change, the way our legislation is drafted, you can challenge activity, but only really through judicial review, which is the form of decision-making in which the public authority has acted. So there's not really any scope to say, well, we'll grant an injunction. That means someone else can use it. That means the emissions can be reduced. That's just not part of the toolkit broadly. So I've tried to develop some arguments about how that might be done. They're a bit crazy, probably, but I still think they're rather fun. Thank you. More work. I think it's more straightforward to build on some of the cases that I mentioned when I was speaking before. If someone does sue someone for patent infringement for trying to build a wind farm, for example, in the UK, at least for now, and hopefully we will continue to have, we have the Human Rights Act. There are lots of arguments based on wild law. There's arguments in relation to precaution. I think one really can try and say, okay, we're not going to grant you an injunction. And maybe a next step beyond that is to try to widen interpretations of exceptions or perhaps narrow interpretations of scope. But while interesting to develop, they are, I think also slightly disappointing, or one shouldn't have to argue that a patent should be narrowly interpreted to solve a problem that should actually be solved in a very different manner. It would be much better if one could actually draw legislation together and make clear the problems which are there. And I'm also very much aware that I'm looking at a very narrow set of circumstances when fights don't arise very often. The previous discussion about how we can enable licensing is much more important, and if one could create that type of framework, then the disputes are not going to arise. But I think it gets so much publicity when there's a piece of litigation that people are fighting about wind farm technology, say, And then I think that can make people, we've seen this in many sectors over the years, people are very, very reluctant to take a risk. They're reluctant to get involved, and that can have very important implications for us all.
Okay. About court, would you believe that proportionality exercise when discussing injunctions could be a possibility? Because some scholars also discuss the difficulties with even starting discussing injunctions, exceptions, that does not really work at the practical level. And some people are discussing now proportionality exercise when talking about remedies for IP infringement.
So yeah, I think that can definitely work. And whether you term it very broadly, whether you term it proportionality, whether you term it the public interest, I think those are the things that courts do have regard to when they are awarding remedies. There's things that one can draw, for example, from privacy litigation in previous years in relation to I think cardiac-based systems. There's been some cases like that in the UK. So I think proportionality can work. For a lawyer, it's fab. We love proportionality. And, I used to be a practitioner for many years. Colleagues who are practicing on the call, that's really important for your individual case. I suppose I'm always a little mindful that that's great for one case. It's not great for the situations more widely.
This point actually connects to my second question, which is the coherence of the policy measures, because when you do not have an engagement, an explicit engagement between intellectual property and these climate change challenges and other challenges that we are discussing, there is a higher chance that there is lack of coherency between these policies, particularly when they are dealing with IP. And then in the last slide, you have something like unchallenged assumptions of industry, public and private sector. And this, of course, connects to the lack of coherence, because if you do not challenge the assumptions, you just follow what you always do, and then you don't really see what other people are doing. So maybe you could elaborate a bit on that and give us some examples of how that actually plays at the level of implementation, for instance.
Yeah, so I think some of this goes back to the first discussion that we had after my presentation, that if one assumes that we have patents which encourage innovation, we have more patents, that must mean we have more innovation, and that means people will use it, and this will be a good thing. It's just more straight. It's not as straightforward as that. That's involving people changing their practices. They might need 4 or 5 different patents to be able to launch a particular product, for example. It might be too expensive. They might be encouraged on one side to reduce emissions, but equally they might have to pay so much money to get a license for new technology, if any patent owner is even willing to license in the first place. So they won't do it. Now, I'm also very much aware of, one can quite quickly go into competition and anti-competitive agreements-based situations. So I really look forward to our next type of discussion. But I think it's removing the barrier. I think policymakers, and I don't criticize this, I think it's a very deep structural systemic point. If your job is to encourage technological innovation and climate change, whether that's through prizes, for example, then that's your job. And there's an assumption that people will use it. And then if you're an IP, it's, yes, remember to sue them, because if you sue them, then that's a disincentive to others too, and you'll make more money. But that, back to our first speaker, that's not the right framing. The right frame is to encourage everyone to use it. So there's almost, I think both the present approaches to IP and climate change, they do make sense, but they don't talk to each other. And I think this is right back to that private-public split, which is unavoidable. I'm very interested in some of the mission-based approaches, and this idea of trying to, it's not just one industry, it's a whole state-based approach which one might take to that. Hopefully that will gain a lot of momentum, but even within that, actually, there's the book I'm writing at the moment is it's about who gets in the room and how wide is your room, while aware that your room probably does have some doors eventually, and no one can be expert in everything. So how can you bring people together? How can you try to build a new, really constructive coherence, when that coherence might involve some quite challenging decisions? For example, the most important thing is not traditional shareholder profit. if that's how your business or your economy has always run, that's really quite a big challenge. But equally, a lot of other rooms, I think, are full of people who are understandably very much focused on we must reduce emissions however we can, and are not mindful of the really important need to reward shareholders and encourage innovation. So how do we draw those things together? And I think some of that's through education, through what we do at universities, through policy space. For some of it's, I think, some really very high level leadership as well to look at or to look at changing the dial and to look at how to bring people with them in that. And if anyone knows the answer, I'd really love to know.
Yeah, thank you. So before I give the floor to our next speaker, I would just like to invite our participants to, should you have any questions, to submit them here in the Q&A chat below. So our last speaker is Professor Joyce Young, and she'll be discussing with us exactly this interface between intellectual property and other areas of law, such as competition law. And she will also bring us some examples on existing intellectual property collaboration mechanisms that we have at the international level and also at bilateral level, such as China and the US. So Professor Joyce Young, the floor is yours.
Thank you, Felipe, and thank you, American Society of International Law, for the opportunity to have some time together to discuss this rather engaging topic. Next, I'm going to share my PowerPoint. Can you see the full slide?
Yep.
Okay, great. All right, so thank you, Abby and the General, for the discussion. Continue on with my colleagues' discussion. I will focus on these two major points: intellectual property right, antitrust, and access to essential clean technologies. And then how do we conduct intellectual property right management in the international collaboration for clean tech development and clean tech transfer. Much of my research has been condensed into this book. In this book project, I did research about what would stimulate global clean tech development and rapid diffusion of the result. So the finding from this project is that I conclude that IP protection is rather necessary for developing countries to attract the needed foreign direct investment and to conduct inbound clean tech transfer, and IP protection is also necessary for us, for the global community, to find the necessary clean tech breakthroughs that will help us to catch our goals for climate change mitigation and adaptation. I also agree with other scholars, some of the scholars in the field, that private sector does play a rather important role in both clean tech development and the clean tech transfer. So my second major finding conclusion is that according to the empirical data, international clean tech transfer has been rather limited. And the developing countries do need significant inbound clean tech transfer. And like Professor Shabalala mentioned, that clean tech IPR has been a tension point in the international clean tech transfer. And my conclusion has been that clean tech IPR has not been a major barrier for international clean tech transfer to developing countries. I consider that capacity building in developing countries, especially the least developed countries, is very necessary, and we need effective, consistent international support for these countries to build up their capacity for absorbing and localizing foreign clean technologies. So based on these findings, I proposed a solution. The solution is that to enable clean tech transfer to developing countries, the global community needs to provide effective, consistent support through international aid and through international clean tech cooperation. And to enable global and local clean tech innovation, I suggest that developed countries do take the leadership role in research development in order to find the clean tech breakthroughs that the global community need for climate change. Meanwhile, for developing countries, I proposed a pathway. The pathway is especially targeted for least developed countries, that is to leverage international aid to build up basic capacities that can be used to support local implementation of foreign clean tech. Then also build up a local infrastructure for setting up, for the future setup of a local clean tech industry. Then the second part of the pathway is once there is a basic local infrastructure capacity for implementing clean tech, even for producing some local clean tech, then the country can step into mutually beneficial international clean tech cooperation. In that way, they can bring in advanced foreign clean tech and integrate with local clean tech and generate locale appropriate local clean tech. And eventually, the developing countries can graduate to have a solid domestic clean tech industry capable of creating self-sustaining local clean tech innovation. So the major discussion in the research is about international clean tech transfer and international clean tech development. For international clean tech transfer, I like to zero in on the issues that developing countries have been voicing. The major observation for many developing countries is about the difficulty to access foreign clean tech. And because of the complexity of foreign clean tech, usually it is the multinational companies from the developed countries that own such technologies and are the exporters of such technologies. So therefore, they have been observed by entities in developing countries with such behaviors, including refusing to work the clean tech locally in developing countries, refusing to license the clean tech developing country needed at fair terms, for example, charging excessive prices for licensing the clean tech, and in technology transfer contracts install anti-competitive provisions restricting the transfer and implementation of the technology. Based on these complaints, I looked at available options in international IP regime and also in antitrust regime, try to figure out if there are ways developing countries can address such actions they complained of the multinational companies, the clean tech owners. So here is most of the venues that I saw that we can use in the existing competition law regime and IP regime. Today, I'm going to zero in on the mechanism available in the competition law regime that is about the grounds available for charging the technology owner in abuse of a dominant position by refusing to license and by charging excessive or abusive price of the technology needed by the entities in developing countries. So the remaining items on the slide are the mechanisms available in the current IP regime that developing countries can explore to improve their access to clean technologies. So for the competition regime approach, the venue provided in leveraging the abuse of dominant position tool provided by the competition regime. I compared the approach taken by the three major jurisdictions, US, European Union, and China, on how they regulate the refusal, these major behaviors by clean tech owners in clean tech transfer, such as refusal to license, excessive abusive pricing in the clean tech transfer. So this table captures and compares their corresponding approaches. So for example, for refusal to license the necessary clean tech that asked by developing countries, US considered it's only actionable under exceptional circumstances. IP owners has no obligation to license the intellectual property. And the EU has similar approach in this aspect. However, China says an IP owner can refuse to license only with valid justifications. Under the refusal to license ground, there is a doctrine said essential facilities doctrine. The essential facilities doctrine would allow the mandatory license of a technology if the technology is deemed as essential for an entity to, for example, enter the market, the relevant market. Okay, so currently, US does not favor this doctrine and walked away from recognizing IP as an essential facility. However, both EU and China takes the approach saying that intellectual property can be regarded as an essential facility. Therefore, the IP owner can be mandated to grant access to the technology behind the IP protection. And EU and China takes a similar approach, consider excessive abusive pricing can be considered as a ground to be regulated for abusing a dominant position. Based on these approaches by EU, China, and the US, I proposed a possible approach for leveraging, for developing countries to leverage competition law to regulate the access to essential clean tech. So first factor is to set a broad, diverse objective list for the competition law in the developing country jurisdiction. Consumer welfare, social welfare, public interest, healthy national economic development, and sustainable development can all be considered as diverse objective for the competition law. And learning from Professor Brown's research, define what can be essential technologies to satisfy essential social objective in a field, and also can learn from the process for identifying standard essential patterns to define what technologies can be essential technologies in the relevant market. Okay, and make refusal to deal with excessive pricing as actionable grounds for finding abuse of dominant position. And the government has ability to either mandate a license from the clean tech owner to facilitate a voluntary license, or to deny a clean tech owner's request for injunctive relief against European country entities' use of such essential clean tech. Okay, so there's different considerations for developing countries to implement such approach. For time consideration, I will just display it on the screen. Okay, so my next discussion point is about different models of managing IP rights in international clean tech cooperation, whether it's cooperation to develop clean tech or to deploy clean tech. As one of the previous speakers discussed, there is a tension, a dynamic between developing countries and developed countries. They have different view, different mode on how to regulate clean tech IPR. Developing countries prefer to have weak or prefer to limit clean tech IPR. Developed countries consider clean tech IPR motivates further clean tech innovation and facilitate clean tech deployment. So here today, I mainly want to discuss about the models of creative collaborative IPR management. So creative IPR management can include one, separating the incentive function of IPR from the access function of IPR. For example, instead of following the usual approach of asking the IPR user to pay for the access a third party can step in to pay for the access, such as the government or a public entity. And IP users can also pull together their clean tech needs and to have a collective clean tech procurement, so to increase their bargaining power with the clean tech owner. For cooperative IPR management models, these are the different options. So today I'm going to quickly go through a couple of examples about the cooperative IPR management. So one example is the WIPO Green initiative. So WIPO Green initiative is open access online database set up by WIPO, where clean tech solution providers can input their solutions about the products, services they provide, and the clean tech solution seekers, they can post what they need for clean tech. Then the database acts as a marketplace to match up the clean tech solution seekers and the clean tech solution providers. So what's interesting here is that WIPO Green actually stay clear on how the two parties can form and manage a transaction once there is a match happens. And in the process, WIPO Green does consider that IPR should be respected, and they should be the facilitator and be an integrated part of the transaction for the clean tech match. So far, WIPO acts as the intermediary to provide services for the formation of such transactions. For example, access to the WIPO arbitration mediation service, as the previous speaker suggested, and have an advisory board to enhance the WIPO Green offering. WIPO Green has been rather successful. By the end of last year, it has collected 129,000 clean tech solutions and has already made more than 1,000 connections between the clean tech solution seekers and the providers. The second example is the Climate Technology Center network provided under the UN FCCC framework. So what CTECN does is, after receiving a request from individual developing countries, it works with its partners, technology solution partners, for example, to deliver a portfolio of suitable technology solutions. CTECN, meanwhile, also provide advisor services to provide the associated policy, legal, regulatory framework for the suggestions for the individual countries to implement the technology solution according to their local specific demands. And the CTECN work together with WIPO produced 2 green technology books. So the IP position illustrated in these 2 books actually reflects the WIPO's official positions about respecting, recognizing the importance of IPR for both clean tech development and deployment. The last example I want to provide is the US-China Clean Tech Cooperation. This bilateral cooperation was regarded as the most ambitious bilateral clean tech cooperation. And this cooperation started from 2009 and was wrapped up recently under the current Biden administration. 1,100 researchers, at least, so many researchers from both countries participated, including private sector participants and public sector participants. What's relevant for our discussion here is the intellectual property right management model. I will identify the quick points in this model. So this model needs to be accepted by all participants into the cooperation. Here, it asks the participants to disclose the background IP they bring into the cooperation. And the participant, the non-owner, needs to obtain a license to use such IP. The two parties, the owner and the user, will decide the license term. Then the project IP are the IP created, invented during the cooperation. If the invention, the IP coming out from the defined scope of the collaboration, then both parties are to own the IP. If it only come out from participants from one country, then the participants from another country will negotiate to get a non-exclusive license to use this project IP. So this IPR model, management model, also encourage participants to share the data, the information coming out from the collaborative work with the public, unless there is a need to preserve the confidentiality of such information. This model also offers a dispute resolution path. If parties cannot reach a mutually agreeable resolution of a dispute, then the party needs to use an international arbitration tribunal. So this is considered a good enhancement of conventional behavior, where disputes usually goes to the local court, where suspicion of preferential treatment usually can occur by the non-local participant. So the IPR management framework has been commended for reducing risks in the IP sharing and the inherent uncertainty in creating new IP in international bilateral clean tech development collaborative work project. So at the end of the project of this collaboration, which was wrapped up a couple of years ago, a review of the project actually, surprisingly, reveals that even though the collaboration lasted for more than 10 years, actually there's no co-invention. That is, invention produced by participants from both countries. Therefore, there's no co-filing of new IPs coming out from this collaboration. So this is an interesting phenomenon, okay? What caused for such a phenomenon? So that's something will be interesting to discuss during the Q&A. And a reality of the patent filing shows that the US participants, they only filed patents on new IP coming out from the collaboration in the US. The Chinese participants, meanwhile, filed patents in both jurisdictions. Okay, what caused such behaviors? So that's another discussion point. If you're interested to know more about how China conducts collaboration in clean tech development and deployment, I recommend Joanna Lewis's new book. Thank you very much. That's my discussion.
Thank you, Joy Xiang. So I do have a couple of questions for you, but I would like to invite the participants to submit their questions in the Q&A. And while they do so, I just going to ask you then one question about this second discussion that you had on IPR management, international clean tech cooperation, because as you said, the initiative by China, US and China, was terminated by the Biden government. An issue with these voluntary mechanisms is that it's hard to make them resist some political pressures when they come. So my question for you is, what lessons can be learned from this initiative, and what mechanisms should be in place to make these technology sharing initiatives more resilient, exactly to withstand such geopolitical turns and pressures? Because they are voluntary mechanisms, so they are not exactly enforceable or hard law. So I would like to hear your thoughts about this.
Okay, so there are two parts to your question. So I will address the first part first. The lessons learned from this kind of bilateral initiative is that, like what the US-China model did, is to offer a clearly defined IPR management framework. Okay, even though this US-China bilateral initiative has stopped by the US administration, it does not mean that what this initiative offered in IPR management has failed. Okay. So the second lesson learned is that with this kind of bilateral setup, parties' confidence in each other's IP regime is very important. It has huge implication on what kind co-development of technology fruits can come out, and how that fruits can be diffused into the local jurisdictions. So for example, in this case, as I noted, when there's no filing of co-invention, okay, why is that? The discussion in the field has been suggesting is that both parties probably were being careful not to share valuable, important technology information with each other to make sure that no important invention will come out, therefore will be co-owned by both parties. Okay, and why US participants only file the new IP in US and not in China. Okay, so in this kind of bilateral initiative, building confidence in each other's IP regime will impact the new IP generation, also will impact the subsequent diffusion of the new IP, new invention in the local jurisdictions. And yeah, so those will be the two most important lessons learned concerning IPR management in bilateral collaboration. And the second part of your question is about inbuilt mechanism for this kind of technology sharing to make sure it's resilient, go beyond exterior factors such as geopolitical turns and pressures. This is an excellent question. However, I would say that one, the IPR management model offered, exemplified by the US-China initiative, is still a go-to mechanism, even though need to be improved. okay, the stopping of this bilateral initiative does not say that the IPR management model failed. Okay. The second point is I do strongly suggest we still turn to win-win volunteer licensing mechanisms to continue the technology sharing initiatives. So the WIPO Green initiative is a technology sharing, offers technology sharing platform. So in this case, the WIPO Green organizers, they do not get in between the parties to manage the IPR involved. They let the parties work out the IP issues underlying the transaction. So however the party arrange it in a voluntary win-win manner will be the underpin for a successful clean tech development and deployment transaction.
Okay, that is an answer to my question, yes. I noticed that we have not received the questions from the audience, so I would then, if you allow me, is it okay if we go, let's say, 10 minutes over time for the panelists, or do you have other engagements?
Yep, that's fine.
Then just because I would like to ask her another question, and we'll ask you just to wrap up by making final comments. So just another question by Joyce Young is the issue with IP competition law. You had a very interesting table comparing the different initiatives, and then you have had a suggestion on a kind of a competition law and access to essential technologies. Would you think that it would be useful to have more guidance on international law, on competition law, because differently from IP law, the norms on competition law, for instance, on the TRIPS, are much softer and much less specific. And would you think that would be helpful having this guidance on the international law to address some of the implementation issues that you mentioned in your slides, or not?
That is another excellent observation, Philip. So, as you said, the international regime currently do not have as strong regulation on competition law regime, law and practices. the international IP regime through different international treaties have a much stronger regulation guidance on IP practices. My preference is let's stay the course for international competition law regime. The reason being that I do consider I'm thinking from the point of view of developing countries. Developing countries already has a considerable guidance under the international IP regime through TRIPS, through Berne Convention, through Paris Convention, etc. They need to observe the minimum standards set up by the international IP regime, which to some countries do limit their local development, at least in certain time frame. Okay, so I would like the international competition law regime to stay course, which is less developed than the international IP regime. Therefore, developing countries, they can have some room in their local jurisdiction to allow the access to technology they need, give them sufficient flexibilities to manage locally. At the meantime, you talk about guidance. I think currently, in international competition law regime, even though there's no multilateral treaties in place to provide standards, for competition law set up. However, there are informal networks such as offered by the International Competition Network and such as the system set up by how do we say UNCTAD, right? They offer regular periodical conferences to guide countries in implementing competition law and offering them best practices. So all these informal norm settings, I think they are enough for developing countries to have guidance and also meantime to have some space to develop their local economic development, sustainable development with sufficient policy space.
Thank you. So I would just then invite all the panelists should, in 1 minute, make their final considerations and maybe based on your reflections from your colleagues here that were presenting to conclude our panel. So maybe we can start with Professor Shabalala, then Brown, and then Chiang, and then we'll be done.
Again, thank you so much, everybody. I really enjoyed. I have so many questions. My main, I think, takeaway is sort of threefold. One, I think, is that I think if each of the presentations suggests to us that the existence of patents is not really the question we should be asking, right? The fact that patents exist is not the right question. The right question is going to be the one, how are they being used and how are they being imposed, and how courts, I think, as Abby pointed out, are responding to demands to limit access to those. Secondly, I think the cross-border question is crucial here because I think the thing that we don't always see is that it's a struggle not just between countries, but also, I think the example is within countries as well. And that we need to really be thinking about what the models are for diffusion generally, not just the cross-border limitation of diffusion. I think the final thing, I really think we need to be really aware of the market here. That I think the question that we really should be asking is not whether we should be building up the absorptive capacity of the LDCs, whether we should be spending 20 to 25 years helping the LDCs develop so that they can then absorb the knowledge and have the capacity to absorb the knowledge. I think that's missing the point, which is we need to be focusing on the middle income countries who already have that capacity, who already have the absorption capacity, and who have the capacity to produce climate technologies at a huge volume and a huge rate, and talk about how to enable them to supply at a minimum the LDCs, but also everybody else, right? The solar PV example with China is clear. The wind example is clear. The EV car and battery example is clear. That we don't get a lowering of the cost curve, the lowering of the adoption of anything without the ability to engage in kind of mass production that we can get from the advantages of China, India, Brazil, and others like that doing it. And so when we're thinking about addressing this as a barrier, we shouldn't just look at FDI into China and other places or FDI into those places, but also what those countries are doing in their capacity to other countries. And I think that's something we don't have enough research on, enough data on. We have the bilaterals between developed countries and China and India and Brazil, but the third country data we don't have. I think that would be a really important thing to think about. How do we increase that kind of, we sometimes call it South-South trade, but I think middle income to lower income country technology transfer and trade, I think is crucial.
Thank you. A.B. Brown?
Thank you. Yeah, funny, just when you were speaking, so I just scrolled down. Ravi Srinivas, my colleague who worked on a previous book, and he does talk about South-South. But I think yes, I think both in terms of the market, where the demand of what the needs are, but also perhaps there's the assumption that everything is developed in the global north or west, and that's not true. So to really move away from that, I think, is important. But I think the market point also feeds into, my main view, which I said before: barriers down, look over the edges, see what's happening in other disciplines, but also, industry talking more to government, engaging more with courts, because one can develop fabulous policy-based and legislative-based solutions, but if industry is not involved, things aren't going to work. Industry will simply continue to operate as they always have. So I think a very intertwined partnering approach, which there's a lot of base for that. WIPO Green, UNFCCC, some of the very practical climate change and IP-based initiatives. So I think, continue talking, but continue being willing to do things in a different way. And sadly, I think the urgency in relation to climate change, as we've also seen in relation to COVID, might be a way of really trying to unlock some new practices. Thanks. And thank you very much for this fabulous discussion.
Great. So my conclusion from this panel discussion is that, first of all, I do agree that the source-to-source mode of technology development, technology transfer is an area we need to look more into. And the exporting of products, services from mid-level developing countries, emerging economies to other developing countries is a very interesting path. My conclusion, my focus in the research of clean tech and IP has been focused primarily on the LDCs. Okay, so I do think the international community needs to support the LDCs through international aid so that they eventually can stand on their own feet and to engage into mutually beneficial international collaboration. And from there, hopefully, will find their own niche to develop their own domestic technology industry, whether it's for clean tech or for unique natural resources. And my other point from this discussion is that I do consider that we should not impose more applications on developing countries, especially on the least developed countries. We should preserve the existing flexibilities available for them and give them, provide them best practices, provide them with assistance on implementing a local situation that fits for their local conditions, local characteristics.
Okay, so thank you all for your final remarks. And yes, I thank you all for joining this panel. I hope there will be a follow-up, and I hope to see you in future events organized by the ASAL Intellectual Property Interest Group. So thank you very much, and see you next time.
Thank you, everyone.